Well, the governing African National Congress has moved to allay fears after the Zulu king Goodwill Zwelithini's Imbizo yesterday, in which a number of threats were made should the Ingonyama Trust be repealed. The trust was established in the dying days of apartheid as an agreement between the former Kwa-Zulu government, and it really paved the way for the participation of Ingata in the first democratic elections in 1994. And of course, we've seen that since the finalisation of the Constitution in 1996, the Act has been amended to ensure it meets constitutional muster. Yesterday's gathering has sparked debate around the country and raised a number of questions, including how the trust fits into the wider land debate and who actually benefits from it. We're joined now by Dr. Aninka Claasens from the University of Cape Town, and she's led extensive research on this issue, and she's in our Cape Town studios. Good evening to you. Firstly, let's go back to the beginning. What was the original mandate of the trust to hold, of course, that land for the benefit of those who live on it?
Sorry, are you addressing me? Can you just repeat the question?
Yes, indeed. What was the original mandate? Presumably, one would think it was to hold that land for the benefit of those who live on it.
So basically it was in 1994, and it was at the period where the homelands were being reincorporated into South Africa. And all the other homelands, the land was held in trust by the Minister of Land Affairs at that time, but a negotiation was undertaken between the Inkatha Freedom Party and the apartheid government that instead of the land in Kwa-Zulu being held in trust by the minister, it would be held in trust by the Zulu king. And the idea was that that would be a temporary measure because in the long run, people's land rights would be formalized and it would no longer be necessary for land rights to be held in trust on their behalf.
Well, as I said in my introduction, the Act was amended in 1996. Now, those in support of the status quo argue that if it made constitutional muster, then what's the issue now?
Well, basically, it's how it is being implemented. And normally, if an act is being badly implemented, you can't strike it down as unconstitutional. You rather say improve the implementation. But basically, there are really serious problems with how the act is being enforced. And it's being enforced in a way that abrogates basic constitutional rights and actually contradicts the act itself.
It has also brought to the fore the tension between the supremacy of the Constitution and customary law.
Well, I strongly believe that customary law is an important source of law and is an important. It provides very important rights like land rights, and in fact, the Ingonyama Trust Act says that the land must be administered in a way that upholds Zulu customary law. And I would argue that Zulu customary law provides for ownership of land by the families who've occupied it and lived on it for generations. And unfortunately, the trust board has taken to leasing that land, which is owned by families according to customary law, to them in return for rents. And basically, it's taking that rental income for itself and turning people who are customary owners into tenants. So I don't think it's a clash between customary law and the Constitution. I think it's a clash between how the trust administers its mandate and customary law and the Constitution. So I think customary law and the Constitution are on the same side.
So ultimately, it's not a question of those tensions, but rather who benefits from the Ingonyama Trust. And from what you're saying, it doesn't appear it's the rural residents. Is it only the king and those connected to him?
Well, this is one of those really difficult questions because the trust has got qualified audits repeatedly. And questions are raised every year in Parliament about who is getting the benefit from the money that's generated from poor people when the trust is meant to act in the interests of those poor people, not fleece them. And, one wonders, this massive indaba, how that was paid for. And one only hopes that it wasn't paid for by rent that's been extorted from people who are actually the owners of that land.
There have also been all sorts of accusations and allegations around how the trust operates, deals with multinationals, including mining rights. We've seen issues around, for example, game farms and that sort of thing. I mean, what's going on as far as that is concerned?
So I think, yes, there are two issues. The first issue is the trust leasing land to the people who already own it. But the other, which has had really serious impacts, is the trust leasing land to third parties. And that's land where people have got historical and current ownership rights. And yet those people are not consulted. The trust board interprets its mandate to say that as long as it's got the written approval of a traditional leader, it can enter into these third-party agreements, which basically confiscate people's land rights without expropriation and without compensation. But actually there's a law called the Interim Protection of Informal Land Rights Act, which says that nobody can be deprived of an informal right, especially in the former homelands, without their consent except by expropriation. And Parliament has, the Portfolio Committee on Rural Development has pointed this out to the chairperson of the trust, former Judge Jerome Ngwenya, and demanded that the trust stop issuing these leases. But it appears that their retaliation has been simply to call these large meetings and make threats about the Motlanthe high-level panel recommendations, which are only recommendations to Parliament. It's one of over 100 recommendations. And so to say that this is a decision by the ANC or by the government to move against the trust is to completely and absolutely misinterpret the status of those recommendations to Parliament.
So is it then disingenuous to link this particular issue to the wider discussions that have been happening on land in the country?
Yes, it's disingenuous to link this discussion with the discussion about expropriation without compensation. Because just as the Ingonyama Trust Act was created by legislation and the trusteeship was transferred to the king, subject to people's existing rights. So if there were a change, it would also be by legislation. And again, it would be a different trustee, but subject to people's pre-existing rights. So it's really got nothing to do with the discussion about expropriation without compensation, because actually this land is state-owned, as the trust itself has argued in litigation about the payment of rates and taxes in Durban.
So support for the king seems to have come from an unlikely source, the leader of the EFF. Ultimately, what this is going to require is political will to act on behalf of the rural folk living on that land. Do you think it's there?
No, I don't. I'm afraid I don't. I think it's not just in KwaZulu-Natal that we have this problem. We have this problem in all the former homelands, especially on land affected by mining. And what we're seeing at the moment is really the confiscation of black people's surface rights to land in the name of mining, and an interpretation of the MPRDA, which basically says that if you have a mining right, you can simply confiscate people's rights without expropriation and without compensation. And this problem has been brought to the attention of the government and of the ruling party by numerous people in numerous public hearings, and it seems that there simply isn't the political will to really deal with these ongoing processes of dispossession, both in the Ingonyama Trust areas, but also in the former Leboa, Bophuthatswana, Gazankulu, Mpumalanga, these provinces that have this extraordinarily rich mineral wealth in terms of platinum and chrome and titanium and coal, and are bearing a terrible cost for that mineral wealth, in that people see their houses destroyed, their graves moved, their fields confiscated, and yet they are not consulted, they are not required to provide their consent, and they're not expropriated.
So contrast the scenario that you've just outlined there in terms of how people are suffering because of the resources on their land with what you might call the drums of war that were beating yesterday, certainly as we heard speaker after speaker make threats of violence. Part of what we were hearing yesterday is, where are these people that are complaining? The traditional leaders that were speaking yesterday were saying that people under their leadership are happy with how things are being run. Certainly the Zulu King would insist on that.
Well, I was a member of that high-level panel, Motlante's high-level panel, and we held public hearings. And contrary to what former Judge Ingonyama says, we held a special roundtable with him and others in KwaZulu-Natal to discuss the Ingonyama Trust. We held a completely open public meeting that was attended by senior traditional leaders, which means that others could have attended. And in those meetings, person after person made complaints about how they're treated by the Ingonyama Trust. But you must understand that KwaZulu-Natal is a very violent province. And as everyone saw yesterday, people who come out and give their personal testimonies are in quite a vulnerable position.
Right, so we expect, of course, that this discussion is going to be ongoing. We thank you for giving us some of the facts away from some of the myths we've been hearing on this issue. Dr. Aninka Claasens is with the University of Cape Town. As I said, she's done extensive research on this question.